Good afternoon, everyone. Thank you for joining us for the next in the series of Beale & Company's construction law updates. This follows our previous webinar on CDM 2015 in February 2015. Just some brief introductions. My name is James Vernon. I'm an associate at Beale & Company. I am joined by my colleague Andrew Croft, also an associate at the firm. Before we start, I would like to deal with the usual housekeeping items. This webinar is scheduled to last approximately 45 minutes. During the webinar, you can submit questions to us in the appropriate box in the right-hand side of your screen. We will try to deal with these during the webinar or at the end if time permits. If that is not possible, then we will get back to you by email as soon as possible afterwards. We have approximately 150 people in attendance today, so if you are able to, please can you mute your microphones. The outline for today's webinar is as set out in this slide. We'll start with a quick introduction to the regulations, although I'm sure most, if not all of you, are familiar with what they say now. We'll then look at some of the developments since the regulations came into force in April last year, before diving into the main questions that have arisen regarding CDM 2015. Some of these have been raised by clients, including in advance of today, and we thank you for those questions, and some from discussion amongst health and safety law practitioners. As ever with new legislation, there are contractual angles to ensure compliance, and so after the FAQ section, we will set out our views on the impact CDM 2015 has had on standard form contracts and amendments to those contracts. Finally, we will deal briefly with the new sentencing guidelines for health and safety offences, which came into force in February this year. For information, we will be using PD and PC as abbreviations throughout for the principal designer and principal contractor. CDM 2015 came into force on 6 April 2015. These are the third set of regulations brought in to implement key aspects of an EU directive relating to construction. CDM 2015 contained transitional measures in order that the industry could get used to the changes, particularly in relation to the end of the CDM coordinator role being replaced by the principal designer. These transitional measures no longer apply, and CDM 2015 is fully in force. CDM 2015 covers almost all construction projects in England, Wales and Scotland. Construction work has a wide definition under the regulations. The generic definition is that it means the carrying out of any building, civil engineering or engineering construction work. This includes construction, refurbishment, maintenance, demolition and dismantling, replacement, site clearance, intrusive investigation, M&E installation, removal or repair of services fixed within or to a structure. What is not covered by the definition of construction work includes marquees and similar tents that are designed to be re-erected at various locations, general maintenance of fixed plant, and works to or on vessels such as ships and mobile offshore installations. The key changes brought in by CDM 2015 are the introduction of the principal designer role for projects of more than one contractor or where it is reasonably foreseeable that more than one contractor will be involved, changes to the competence requirements, development of the regulations to cover domestic clients, and changes to the parameters for notifying projects to the Health and Safety Executive. As a result of these key changes, the regulations now apply to small projects, domestic projects, construction work carried out within Great Britain and its territorial seas, and design work undertaken outside Great Britain for use on a construction project within Great Britain. With regard to this issue, consideration must be given where design work is outsourced overseas to ensure that those doing the work are aware of what is required to comply with CDM 2015. The regulations do apply to any person, business or undertaking that commissions and participates in construction work, whether for profit or not. Non-compliance by an individual can lead to a personal criminal prosecution and severe penalties if found guilty. As with all new legislation, it does take time for those it impacts on to understand the changes in their duties and obligations and how such duties and obligations will be enforced by the relevant authorities. This gives rise to queries on interpretation and compliance, and key central issues emerge, which we aim to deal with today. Where there has been difficulty is the fact that CDM 2015 has brought in a big change in how the design pre-construction phase is managed. The principal designer is a new role to be undertaken by a design professional. While the division of these duties may be clear in the HSE's mind, given their prescriptive approach to health and safety legislation, this may not accord with reality on projects. In particular is whether design professionals have the requisite skills and experience to undertake the role of the PD. At present, the industry has not been greatly assisted by the HSE. At this time, no approved code of practice or ACOP has been published. It is now unlikely that one will in fact be issued. An ACOP for CDM 2015 was considered a potentially useful document given the extension of the regulations to domestic clients and the introduction of the PD role. Furthermore, as with the ACOP for previous CDM regulations, compliance with it was a way in which a duty holder would be able to demonstrate that it had done enough to comply with the regulations. What the industry does have is a legal reference document L153 published by the HSE. This explains the aims of CDM 2015, but does not go as far as an ACOP, as it is not a definitive code of practice that guarantees compliance with the regulations if followed. In addition, the Construction Industry Advisory Committee has published some frequently asked questions themselves and a series of guidance for specific duty holders, principal designers, principal contractors, workers, and clients. So before we move on to dealing with some of the frequently asked questions, I wanted to just touch briefly on developments since these regulations came into force. A recent development is a potential amendment to the regulations to relax some of the regulatory burdens on house builders as part of the government aim to deliver 400,000 new homes by 2019. While any proposed change will have to be balanced with the overall aims and objectives of CDM 2015, as well as compliance with the European Directive, this is an interesting development as to the ambit of health and safety legislation being altered to try and reduce red tape in an effort to assist the construction industry. Beale & Company will provide further information on this as and when the government announces its proposals with regard to any amendments.
Thank you, James. As James mentioned, perhaps as a result of the absence of an ACOP and the prescriptive approach taken by the CDM regulations, the industry is still very much digesting the changes under CDM 2015 and understanding how they're going to apply in practice. We will now therefore consider some common queries we have received in relation to CDM 2015. These, broadly speaking, relate to the risks associated with the principal designer role, how CDM 2015 fits in with common procurement methods, and the PD's role during the construction phase. And these questions are all set out on the slide.
One important question is who can be a principal designer under CDM 2015? As mentioned before, the PD role is a new one. It replaces the CDM coordinator, who was typically a health and safety professional. The trigger for a project that requires a principal designer to be appointed is where there is more than one contractor, or it is reasonably foreseeable that more than one contractor will be working on a project. The definition of contractor is wide and will include subcontractors engaged even for a small percentage value of the job. On this basis, we consider that a principal designer will be necessary for almost all jobs. In addition, the principal designer should be appointed by the client as early as possible in the design process, so that the pre-construction information can be pulled together and so that the principal designer has enough time to carry out his or her duties. Therefore, the principal designer will be someone who has control over the pre-construction phase. Indeed, this was one of the justifications for the new role as distinct from the previous CDM coordinator role, as it was felt that generally CDM coordinators were not engaged in projects until just before the construction phase. From our interpretation of the regulations, the principal designer does not need to be a designer on that particular project, but must be a designer. However, if he is not a designer on that particular project, then how will we have the necessary control? Therefore, we consider the principal designer will come from the project design team. The next question to look at is what is a designer under the regulations? A designer can be anyone who prepares or modifies a design or arranges for or instructs any person under their control to prepare or modify a design. Therefore, it may include a design and build contractor, a QS, or a project manager if they have appointing powers for a project. The Health and Safety Executive have suggested that the PD is likely to be, for larger projects, a design practice or a technical department of a principal contractor, for example, a principal contractor doing design and build, and for smaller projects, a self-employed architect or technician, a small design practice, a project management company, a client's internal estates management team, or even a specialist tradesperson, such as an electrician, where they lead on the design function. What is critical is that the principal designer is someone within the design team who has the necessary competence such that he can plan, manage and monitor the pre-construction phase and coordinate matters relating to health and safety during the pre-construction phase. This is necessary under the regulations to ensure that as far as is reasonably practicable, the project is carried out without risk to health and safety.
There is some concern in relation to the PD's duties under CDM 2015, and in particular that they may include absolute obligations, which are not qualified, i.e. that the PD may breach CDM 2015 for any failure to comply with some of these duties, however minor. As shown in the slide, the PD's general duty in Regulation 11.1 to plan, manage and monitor the pre-construction phase to ensure the project is carried out without risks to health and safety is qualified by the words so far as reasonably practicable. However, a number of the PD's obligations are not expressly qualified. This includes ensuring that all designers comply with their duties under CDM 2015, ensuring cooperation, and the obligations in relation to the health and safety file. Some of these duties are expressed to form part of the general duty I previously described, which, as I said, is qualified. Although the HSC has suggested in email correspondence that they consider the duties which refer back to the general duty to be qualified, in our view, there is a real risk, based on the wording of the regulations, that they would be construed as strict obligations. In any event, the so far as reasonably practicable qualification in the general duty is a high threshold, as shown in the case of Edwards and National Coal Board from 1949. A course of action must be shown to be grossly disproportionate to the risk for it not to be reasonably practicable. The implications of this are twofold. Firstly, the threshold for criminal liability to be established against the principal designer is relatively low. Further, if, as is common, as I will explain later in the talk, the principal designer's appointment contains obligations which repeat CDM 2015, civil liability for breach of such obligations could be established even if the PD has exercised reasonable skill and care, i.e., even if it has not been negligent. Some professional indemnity insurance policies provide cover on a negligence-only basis, so this is an important point. Any PD appointment should be carefully considered by insurers.
The next question we're going to look at concerns CDM 2015 on design and build projects. The CDM regulations apply to those projects. One facet of these types of project is that the contractor is likely to be a designer as previously defined. As such, will they take on that role? This will depend on when the design and build contractor becomes involved in a project. If they are not involved from the outset, then under the CDM regulations, the client will have to appoint a separate principal designer first for the pre-construction phase. This would be the norm for projects, for example, that go out to tender. As we see it, there are three possible scenarios. Firstly, the principal designer role is novated with the design services to the design and build contractor. Secondly, the principal designer remains appointed by the client, but his or her design role is novated. And thirdly, the principal designer role is ended, but the design role is novated. Under the first scenario, the contractor may wish the principal designer to be novated to the contractor. However, on novation, the principal designer will no longer be appointed by the client as required under CDM 2015. As such, it appears that they cannot continue to be a principal designer on the wording of the regulations, although they can continue other design duties. Under the second scenario, if the principal designer is not novated, it is our view that retaining the principal designer role in such a situation will be difficult to manage. When a design and build contractor is appointed, it is likely to be difficult for another designer to be a principal designer given the control issue. The design services being done by the principal designer may be novated, and this goes hand in hand with our view that PD appointments, if possible, should be separate from design appointments. Under the third scenario, where a designer has been appointed the principal designer and a design and build contractor wins the job, it is possible that the role of principal designer is transferred to that contractor. In this respect, it is important to note that there should never be more than one principal designer appointed at any one time. Where such a transfer of the principal designer role takes place, it is important that any other roles being done by that principal designer on the project, for example, if they are the architect carrying out further design, continues in accordance with their design appointment. When a principal designer role is transferred, the HSE have advised that the second principal designer on the project is not responsible for ensuring that the initial principal designer has met their duties under CDM 2015. However, we do not consider that this is clear from the regulations. In any event, in such a scenario, there will be a need for some design review as well as discussion between the two principal designers to ensure that all the relevant health and safety information is passed over and the second principal designer understands what has been done to try and reduce health and safety risks as far as reasonably practicable. Further, it is not clear whether the first principal designer is under any obligation to advise the client to ensure that the second principal designer has the necessary skills, knowledge and experience to carry out the role. We do, however, consider it prudent to make such a statement if you are the outgoing principal designer. If on design and build projects, the design and build contractor does not want to be the principal designer, then if you are the principal designer, we recommend that you ensure that you will have control over the design process, which may be 100% done in-house by the contractor, and that there is a clear procedure for resolving any conflicts of interest.
Can you refuse to take on the PD role? Generally speaking, yes, you can refuse to take on the PD role, and a number of consultants are refusing to do so. Although working for domestic clients, the role may be imposed under CDM 2015, despite you having refused to take it on. And if you do refuse to take on the role, it is important that another member of the project team is appointed in writing. So, the client must appoint the PD in writing for them to be appointed as PD, unless it is a domestic client. If a domestic client fails to appoint a PD, the designer with control of the pre-construction phase is the principal designer. So when working for domestic clients, it is very important to ensure that a principal designer is appointed in writing, if required, to avoid confusion as to who is the PD, and or to avoid a designer unwittingly being deemed to be principal designer. Nevertheless, when working for clients who are not domestic clients, even if you have refused to take on the role at the outset, it is very important that another party is appointed as PD. If the project proceeds without a PD being in place, the client must fulfill their duties. If the client is not prepared to do so, there may be a risk of the design team being brought into any enforcement action, if there is one, on the basis that the design team did not ensure the client was aware of its duties under CDM 2015. Or, for example, because the client might have thought that it had appointed one of the parties as principal designer. It is therefore important to ensure that a party has been appointed as principal designer in writing before starting work on a project. Can the principal designer role be subcontracted? As we've said previously, the PD must be appointed in writing by the client. HSE guidance published on the CITB website makes clear that the law does not allow the PD to delegate their responsibilities elsewhere. The HSE have acknowledged that the design organisation or project management team who it expects to take on the PD role may initially lack some skill, knowledge and experience to do so. The PD is not therefore prevented from bringing in or buying in the services of specialists to ensure their organisation is equipped with that skill, knowledge and experience. And a number of PDs are appointing CDM advisors to do so. Nevertheless, the HSE's view is that appointing CDM advisors is a temporary mechanism of support, which suggests that there will be risks for PDs who use CDM advisors as a crutch. For example, the Association for Project Safety has published a standard form appointment for a CDM advisor to the PD. This is essentially a back-to-back subcontract with the PD appointment, in that the advisor is essentially required to take on the PD role in full. In our view, this is not consistent with the spirit of CDM 2015. The CDM advisor's role should be to advise the PD, not to take on the role in full. In any event, given that the statutory criminal liability cannot be passed on, if you appoint a CDM advisor, you will need to have sufficient control to ensure that they do not cause you to breach your duties as PD.
The main duties of the principal designer are to plan, manage and monitor the coordination of the pre-construction phase. However, this does not mean the role ends automatically as soon as the construction phase starts. When the construction phase starts, the principal designer must provide the pre-construction information to the principal contractor. This is to enable the principal contractor to plan and manage the design work remaining and the construction work. It may be that the contractor has queries, and so there must be some degree of communication with the principal contractor. Further, it is the principal designer's responsibility to prepare and develop the health and safety file for handing over to the client on completion. This is of course on the basis that the principal designer's appointment has not ended before the project is completed. In the scenario where the principal designer's appointment has ended before the construction phase is complete, then the principal designer must hand over the information they have collated up to that point to the principal contractor, who will then prepare the health and safety file. One example of where this is important and where the principal designer role will not end on the commencement of construction is where there is still design work to be done. In this scenario, the principal designer role continues. However, as discussed earlier, that role may be difficult to manage if the principal contractor is a design and build contractor and the remaining design work is being done by them in-house, rather than by a design team employed directly by the client. Arising from the same question is the issue of temporary works. Traditionally, temporary works was a part of the project that rested with the contractor. However, a principal designer will need to get involved in this element of the works under CDM 2015. This is because the principal designer is responsible for and must have control over the pre-construction phase, which includes any time during which design is carried out. Under CDM 2015, a design includes a temporary works design. And CDM 2015 also expressly provides that the pre-construction phase may continue during the construction phase where there is being design. A principal designer must therefore be in place when temporary works design is carried out, whether during the pre-construction phase or during the construction phase. As the principal designer is responsible for coordinating health and safety with all designers, it must coordinate health and safety with temporary works designers. If taking on the role of principal designer, you should consider liaising with the principal contractor regarding temporary works design and establish a clear process for coordinating that design. If this is not possible, you should consider handing over your principal designer role to the principal contractor after construction starts.
CDM 2015 applies to construction work, the definition of which includes site clearance, exploration, investigation, and excavation, but not site survey. It is not entirely clear, therefore, whether initial ground investigations constitute construction work and fall under CDM 2015. The HSC has suggested that site survey, which are excluded from CDM 2015, is very limited and will only include non-intrusive works. If the works involve penetrative works, even with hand tools, the work will be classed as construction and the regulations apply. Whilst the HSC have stressed that CDM 2015 should be applied proportionately, having regard to the level of risk involved, this does suggest that a principal designer and principal contractor is required for preliminary ground investigations if more than one contractor is involved on the project, or if it is reasonably foreseeable that there will be. A key consideration in relation to ground investigations will be what the project in which those investigations are being carried out involves. If the project is simply the ground investigation, and it is not reasonably foreseeable that there will be more than one contractor, there would not need to be a PD or a PC. However, if, as is perhaps likely, the ground investigation forms part of a bigger project, a PD and PC will be required. If appointed as PD or PC in such circumstances, and your role is limited to these investigations, it is important to make clear that the appointment as PD or PC is similarly limited and will not continue after the investigations are complete.
This next question is a specific one that we have been asked, arising from CDM 2015. We consider it an interesting question as it illustrates the circular nature of CDM 2015, even though it may not commonly arise. In some circumstances, a designer and not the client may appoint a contractor. This would ordinarily be the case under a specific role that designer has under its appointment. For example, a designer at the early stages of the project may be tasked with appointing a contractor to undertake ground investigations, so the results can be incorporated into the designer's foundation design. It should be noted that by making this appointment, the designer also becomes a contractor as defined in the regulations, as it will be controlling or managing construction work. If you are a designer and there is the possibility that you will be responsible for appointing a contractor, you should request that the contractor is appointed directly by the client. Otherwise, if you are the only contractor appointed by the client at that time, by way of making that appointment, you may be the only party who the client can therefore appoint as principal contractor, which would involve taking further responsibility that you may not have the skills, experience, and knowledge to carry out. On a similar point, can a designer be a client? Our view is that it cannot, because a client needs to be the person who procures the works.
Another interesting query we have been asked in the run-up to this webinar is whether there could be two PDs or two PCs on a site at the same time. There should only be one PD and one PC at any given time in relation to each project. However, there may be circumstances when more than one project is being carried out on the same site. Under CDM 2015, a project essentially commences on conception and continues until there is no more construction work to be carried out. Accordingly, if variations are instructed during a project, meaning that additional construction work needs to be undertaken as part of the same project, the PC, and if required, the PD, for that additional work should be the same as for the original project. If, however, the client decides to fundamentally change an existing project, for example, by appointing an alternative project team to carry out amendments to part of that project when the original project is not complete, this may be a new, different project, in which case it would be possible for there to be a different PD and or PC for each project. Similarly, if two very different and separate projects are being carried out on the same site, there could be two different PDs or PCs on one site. The key thing to bear in mind when deciding the way forward in relation to whether you appoint a PD or a PC is whether each PD or PC is able to carry out its role as defined under CDM 2015 without being involved in the other project. For example, can the PD have control over the pre-construction phase? Or to do so, is it necessary for it to be PD on both projects? That was the last of the FAQs, and we thought it would be helpful to consider how the PD role and CDM 2015 is being reflected contractually. The only standard form principal designer appointment published to date is the Association for Project Safety form. As commented previously, the APS has also published a standard form CDM Advisor appointment. Whilst the APS PD form provides some useful protection for the PD, in our view, there are real risks for the principal designer arising under the form. For example, the limits of liability only covers breach of contract, not negligence. The services repeat almost word for word the duties under CDM 2015, which, as commented previously, are onerous. The duty of care is not expressed explicitly to be an overriding duty of care. And moreover, the PD has an obligation to discharge the requirements of a PD under the regulations, which is a very wide obligation. Unfortunately, the amendments published by other contract publishing bodies to reflect CDM 2015 have been relatively limited. For example, to change the year of the regulations, or to replace reference to CDM coordinator with a reference to principal designer. Similarly, we have seen a number of tenders and appointments which refer to the principal designer role, and it is common for the role to be tacked on as an afterthought, or to be shoehorned into existing contracts by inclusion in the services only, for example. One example of this is a statement that the services shall include all obligations of a principal designer under the CDM Regulations 2015. One issue with such an approach is that in addition to the onerous nature of the duties under CDM 2015, as we discussed previously, those duties are often expressed by reference to the PD achieving certain requirements, for example, to ensure that all designers comply with their duties. The duties under CDM 2015 do not say what the PD is actually going to do to meet those requirements, which is what one would expect a scope of services to do. Those taking on the role of PD should consider their appointment very carefully in light of the onerous duties mentioned earlier. Given the absence of an appropriate standard form of principal designer appointment, a bespoke form should be considered, which includes a clear overriding duty of care. As the role is very much dependent upon the client putting in place mechanisms to enable the PD to control the pre-construction phase, any PD appointment should also clearly set out what assistance the client will provide. For example, as per the APS form, it could include a requirement that all designers are under a contractual obligation to perform their duties under CDM 2015. Further, given the risks associated with the PD role, the appointment should include clear mechanisms for the PD to suspend or terminate performance if it is being prevented from performing its duties. In addition, the PD scope of services should be considered carefully to clearly set out exactly what the PD is going to be doing to achieve its duties under the regulations. I will now hand back to James, who will discuss sentencing.
Thanks, Andrew. Another new development in health and safety law are the new sentencing guidelines for health and safety offences and corporate manslaughter, which were published in November 2015 and are due to come into force on the 1st of February 2016. These guidelines are important given that a breach of CDM 2015 is a criminal offence. The new guidelines reflect a tougher and more methodical approach to sentencing, and it is anticipated that it will result in higher fines for serious offences. For companies, once the offence category is determined, which is based on culpability and then harm caused, a court will look at the size of the organisation based on turnover to determine the level of fine given the culpability and harm categories already determined. The guidelines split organisations into categories of size. Large companies have a turnover of 50 million or more. Medium-sized companies have a turnover of between 10 and 50 million. Small companies have a turnover of between 2 and 10 million. And micro companies have a turnover of less than £2 million. By way of an example of the possible range, dependent on the harm and culpability factors, a large organisation risks fines starting at £3,000 for offences with low culpability and harm, up to £10 million for very high culpability and harm cases. In addition to fines for companies, there is also publicity orders, disclosure orders, and for ongoing projects, orders to cease work until such risks are eliminated or minimised as far as reasonably practicable. The new guidelines also provide a new assessment method for fines following successful prosecutions for corporate manslaughter. Turnover again is also a key factor in the level of fine, and it is expected that fines will increase if the HSE prosecutes medium or large companies for corporate manslaughter. As previously mentioned, it is possible that an individual can be prosecuted for a breach of CDM 2015, and for very serious offences, this could lead to an unlimited fine and a prison sentence. We have published an article summarising the sentencing guidelines as it affects companies, which is on our website. As stated at the outset, the above frequently asked questions are the more frequent questions that we have been asked regarding CDM 2015. The answers given are our interpretation of CDM 2015. If you have any comments or queries arising out of any of these answers, then please do not hesitate to contact me or Andrew. Before we finish, please note that our next webinar will be on 27th of January at 12:30, dealing with post-merger integration. It will be given by James Hutchinson, a partner at Beale & Co., together with the Association of Consultancy and Engineering and WK Corporate Finance. Please register your interest for this seminar on our website at www.beale-law.com/events. Also coming up in February will be a webinar on the NEC Engineering and Construction contract. The date for this is yet to be confirmed, so please keep an eye out on our website for this. That concludes today's webinar. I know that we have received a number of helpful questions during the webinar, so thank you for these. Andrew and I have tried to answer some of them by responding to you directly during the course of the webinar, the benefit of having two of us deliver the talk. We will provide a response by email to any further questions we have received that we have not been able to respond to. It remains for me to say thank you for listening to me and Andrew this afternoon. If you do have any queries in relation to the issues we've discussed, or health and safety and CDM matters in general, please do not hesitate to contact us on the details shown on the screen. We will circulate a link to the recording of the website so you can listen to it again if you so wish, as well as circulate a list of the questions received during the webinar and the slides to attendees shortly. Once again, thank you for listening. Good afternoon.